that recording now as well. Awesome. All right. And Bonjour, Minogishigeb, Kriros Indigenous. Hello, everyone. Thank you so much for joining us this afternoon. My name is Kriros Duker, and I'm a citizen of the Chippewa Cree tribe, zooming in today from what is now known as Casa Grande, Arizona, the homelands of the O'odham and Peepash peoples. I work at Native Governance Center as the program manager for community engagement. And on behalf of NGC, I really just want to thank you all for joining us today. Native Governance Center, if you haven't heard of us before, is a Native-led nonprofit that supports Native nations in strengthening their governance systems and capacity to exercise their sovereignty. We encourage you to learn more after today about our programming by visiting our website, nativegov.org, or by following us on social media at NativeGov. Today's virtual event is Understanding and Using Treaty Rights. And we're going to explore a little bit more about treaty rights, their interpretations, and some important cases with our knowledge expert today. This is really a time for learning, reflection, and hopefully it will give you some ideas that spark action as well. Before we really dive into our content today, I would like to go over a few housekeeping items. First, I'd like to remind everyone to submit questions using the Q&A box here on Zoom. We're going to monitor this space for any questions to ask Professor Bob Miller throughout the presentation. And in addition to being recorded, this event is also being closed captioned. So if desired, you can turn those on by using the button at the bottom of your Zoom screen. And then finally, before we really get started with our session today, we'd like to give a shout out to our different sponsors. So thank you to our full event series sponsors. We have Minnetonka, a fourth generation Minnesota footwear company committed to reconciliation work that honors and invests in the Native American community. We also want to thank the University of St. Thomas and their Office of Diversity, Equity, and Inclusion. St. Thomas educates students to be morally responsible leaders who think critically, act wisely, and work skillfully to advance the common good. We also want to thank Trivoy, a certified B corporation that has helped bring over 1.9 billion in housing and economic development to Native communities since 1995. And finally, we want to extend gratitude to the Conservation Corps of Minnesota and Iowa for their support of this event. They're a nonprofit organization and AmeriCorps grantee that engages hundreds of youth and young adults each year in programs and initiatives that improve their access to outdoor recreation, restore natural habitat, protect waterways, and respond to community needs and natural disasters. We're going to start today just by presenting some pretty basic overview information about treaty rights. And then we're going to follow it up by a deep dive with our knowledge expert here with us today, Professor Robert Miller. So first we want to start off just by talking about really what is a treaty. So we want to provide some context for today's event, make sure that we all have a good understanding of what a treaty is and how they work within the United States. So treaties are nation-to-nation agreements between two sovereign powers that should be upheld. In this context, Native nations and the United States entered into treaty agreements, and they are legally binding contracts between sovereign nations that establish those nations' political and property relations. Treaties between Native nations and the United States confirm each nation's rights and privileges. Like the Constitution and the Bill of Rights, treaties do not expire with time. They have the same power now as when they were originally created. And Article 6 of the United States Constitution holds that treaties are, quote, the supreme law of the land, inferring that when a treaty is signed, it is a legal document that cannot be broken. So you might be curious about what do treaties do or what do they include? And the United States used treaties mainly as a means to take land and legitimize the transactions from and with Native nations. So oftentimes treaties were used to maybe formalize partnerships, negotiate peace, or legitimize trade. Treaties were not entirely foreign to Native nations prior to colonization, as they had entered into treaties with other Native nations pretty regularly. And when treaties were made with the United States, Native nations often asked for specific provisions to be written into them. So those might include a permanent land base for their citizens, healthcare, education, sovereignty and self-government, governance, and much more. Treaties were originally drafted and designed by the United States government pretty early on in their journey of becoming a sovereign nation themselves. And having these treaties really showed the world that the country was a sovereign entity of its own. But today we're seeing that not many of these treaties have been upheld or they've been broken. And this is actually done by design. Some of these treaties were signed for maybe a more performative measure or intended not to be followed through on, unbeknownst to the Native nations who were signing them at the time. And there has been a history throughout the US of both challenging and affirming treaty rights, which we're really going to dive into next. But this often reflects the broader struggles here in the US around land, sovereignty, and resources. So while treaty rights have been frequently challenged, they've also been successfully defended and affirmed through different legal action, federal policy changes, and grassroots advocacy, which really just reminds us of the importance of our communities. And so there have been these really big challenges to treaty rights, including land seizures and broken promises. You may be able to think of examples near you, but one example from our service region at NGC would be the Treaty of Fort Laramie and the Black Hills, which are sacred to the Lakota Sioux. There were also termination policies terminating the recognition status of different tribes in an effort to not honor treaties, resource exploitation and environmental degradation. So resources being challenged because there were really valuable resources or minerals in that Native nation. And alongside that, infrastructure projects and land use, which we're seeing a lot today. On the other side of things, treaties have also been affirmed or defended successfully throughout the years. And we see that show up in a variety of ways, but including federal legislation that supports treaty rights. An example of that could be the Indian Child Welfare Act, recognition of different land rights and sacred sites. We're seeing so many different cases around land back today or co-management of different sites, which is really wonderful. And then the affirmation of cultural rights and religious freedoms for Native nations. And so today is really meant to just get you started. We encourage you all to learn more after today, whether you're a citizen of a Native nation or not. But we really want to dive in with our speaker today. And so it is my great honor to introduce our speaker for this session and our knowledge expert, Professor Bob Miller, who is going to really take us away and dive into this topic of understanding and using treaty rights. So go ahead, Robert. Thank you.
Thank you, Cree, for that introduction and the introductory materials. I'm going to share my screen now. I will be touching back on many of the points that Cree has mentioned briefly. Now, let's see. Said I was sharing my screen, but I'm seeing your screen.
Oh, apologies. Let me see if I can fix that. Having some technical difficulties, folks. Sorry about that.
I imagine you made me a co-host, right?
I did. Yeah, go ahead and try that screen share again. Hopefully it will work now.
What I'm seeing is not my computer screen.
Oh. My apologies. Would you like me to try and present on my end?
Yes, just throw up the first screen, please.
Okay.
And I'll stop share, I guess.
Okay. Oops. Apologies.
Well, to get started, I mean, I can talk while she's beginning. And so I am a professor of law at the Sandra Day O'Connor College of Law at Arizona State University, and I've taught Indian law for over 25 years at Lewis and Clark Law School in Portland and at Arizona State. I've written several books and also many, many articles on various Indian law issues. And I have examined treaty rights in many circumstances. And I will show you in the slides today with some links where you can see some of my articles for free and a book chapter that I wrote on my own tribe's treaties with the United States. So we are talking, as Cree said, about constitutionally backed, constitutionally empowered treaty agreements between the United States and tribal nations. I'm now trying to talk without my PowerPoint slides. So I don't want to jump.
Apologies, we're almost there.
Oh, okay, no problem. I'm just getting ahead of myself too far without, because I do use my PowerPoint pretty much as my outline.
Here we go. Hopefully you're able to see that now.
Okay, there's the only thing I will point out, the link at the bottom of my intro there. I have about 62 papers, 62 papers that I have online. You can get them for free at SSRN, which stands for Social Science Research Network. It's a fantastic resource if you've never heard of it. There's over 3 million documents on it from about 700,000 authors. But anyway, that particular page number is mine, and I have 62 papers there. Next slide, please. Advance the slide, please. Now, this is an interesting, oh, stop right there, please. So this is an interesting letter that I use yeah, right there. This is a letter from General George Washington in September of 1783. We had finally signed our treaty with England that ended our Revolutionary War, and England pretty much recognized that the United States is a country and that the fighting will end. You may know that the fighting literally ended in 1781, but it took us 2 years to get the final treaty agreement from England. And so Congress now asks General George Washington for advice on just how to deal. Now we're a government. What do we do? Now we're a country. This is a 4-page letter, and it's called The Savage as the Wolf letter, and you'll see why in a moment. And I usually show it because of the savage as the wolf point, that Washington was denigrating the humanity and personhood of human Indian peoples. But this letter takes on more emphasis, more importance in what we're talking about today. And Cree already mentioned this. Why was the United States interested in treaty making with tribes? And you will see with this letter from George Washington that he said it was the cheapest way to acquire Indians. Treaty making would be far better than fighting wars with tribe after tribe. So this is page 4 of this 4-page letter that he wrote to Congress, giving his advice on how the United States should operate. And by page 4, he gets to the Indian nations. So he says, as we advance, the Indians will retreat, but he says they'll be ready to sell, and it's cheaper for us to buy. Next point, please, Cree. I just highlighted, he said, it's good policy to be on good terms with the Indians and purchase their lands instead, again, of fighting wars. Next point, please. Now, here's where the letter is called The Savage as the Wolf, and I've underlined it because he is comparing human Indians to animals. And he said, if we just try to drive them away like we do the animals, it's difficult. And this will cause, but if we just gradually advance our frontiers, and as we see, if we sign treaties, the tribal peoples will disappear. Next point, please. And here's the just chilling part of it that I normally use. This is a quote. Look at that. The savage as the wolf to retire, both being beasts of prey, though they differ in shape. So American Indian peoples were to be hunted by the United States. Their lands, their assets, their resources were to be taken because God intended that Americans have them instead of Indians. But notice again, the last point I have highlighted there, it's cheaper to do this by purchase than by warfare. So treaty making served a great interest of the United States. And I think Cree mentioned this too. The United States did not begin the idea of treaty making with Indian nations. Every European country that came to North America, Spain, Russia up in the Alaska area, France, England, Holland, Sweden, all of these countries dealt with tribal nations on a diplomatic, political relationship, treaty making. Their Indian nations signed about 108 treaties with England and or the 13 original colonies. So this was a colonial English European idea that tribes were governments, they were powerful, they were nations, and nations deal with each other via treaty making. So the mere basis of treaty making being from the 1600s is an aspect of American Indian law yet to this day. And it's part of why tribal sovereignty is just recognized. No one doubts it because Europeans and then Americans have always recognized it. Next slide, please. Next point. So Cree mentioned this too. Our founding fathers put in the Constitution, Article 6, which is called both the treaty clause, but it's also called the supremacy clause. So maybe you've heard the idea that federal law is supreme in the United States if it ever conflicts with a state law. And this is the provision that states that. The Constitution, the US Constitution, all federal laws of the United States and all treaties shall be the supreme law of the land. So these legal provisions trump state decisions to the contrary, individual decisions to the contrary, etc. So tribal treaties are the supreme law of the land, and again, as Cree had stated, must be complied with, or there can be litigation. But of course, the United States has violated many treaty provisions. But one more point there, Cree, please. This is both important and perhaps a little shocking to know. Congress can unilaterally abrogate treaty rights anytime it wants to. Now, that's kind of shocking. If you and I sign a contract, you on your own or me on my own unilaterally cannot just say that contract's no good anymore. I don't have to follow it. That's not how contract law works. But the Supreme Court has decided that the United States Congress can back away from treaty obligations. Now, it started with what are called the Chinese exclusion cases in the late 1880s, when Congress just changed the law of immigration and excluded Chinese people from the United States. So that's why it's called the Chinese exclusion. And within 2 decades, the Supreme Court said United States Congress can also abrogate Indian treaties. Now, I want to tell you, though, yes, while this can happen, if the United States does this, a lawsuit will surely follow, because what the United States is doing is taking away property rights that tribal nations and tribal peoples have based on that treaty. And under the Fifth Amendment of our Constitution, governments cannot take property without paying due compensation. So there are many lawsuits by the United States against the United States every year by tribes for various claims. But if a treaty is breached and property rights under that treaty are taken by the United States, there should be litigation. So there is at least a remedy if Congress unilaterally abrogates a tribal treaty. Next slide, please. And the next provision. Okay, I have a wild guess here, folks. There are 375 treaties that the United States signed with Indian nations in those years I give you, in which the Senate then ratified that treaty and the president proclaimed it, using the procedure that the Constitution sets out. But I want to make this point, and this is just a wild guess on my own part. Not every tribe has a treaty with the United States. There are 574 federally recognized tribes in the 50 states. And I just have a wild guess there that perhaps only about 100 tribes signed treaties with the United States. Of those 375 treaties, I have a feeling that the Cherokee signed about 15 treaties with the United States. My tribe signed 9 treaties with the United States. So you have multiple tribes, often primarily in the East, as the United States was really beginning manifest destiny and starting to advance and advancing to the Mississippi River, at least, those are the tribes that signed most of the treaties with the United States. Now, this is just a side point, but Congress ended treaty making with tribes in 1871. So there will be no more treaties other than these 371 unless Congress were to change that law. But I want you to hear this. That law is probably unconstitutional. When I get the time, I'm going to write a law review article on this. Other people have made this point before, and I don't know if there should be a lawsuit on this subject someday, but treaty making with nations is in the Constitution, and Congress cannot take away constitutional rights. You have to amend the Constitution. Congress can't just pass a law. So that 1871 law, as several people have said, probably unconstitutional. Anyway, next slide, please, Creed. But, and so here's the point I make, even though only maybe 100 tribes of the 574 there are, even though only about 100 tribes have treaties with the U.S., and even though treaty making ended in 1871, that had no impact whatsoever on the United States political relationship, diplomatic relations with tribal nations. And so that's just the point that I make there. And I forget who called this relationship a treaty substitute. But instead of enacting treaties, what Congress does these days is they come to agreements with tribes through the executive branch, through the Bureau of Indian Affairs, for example, and an agreement is agreed to, and then Congress, both houses of Congress pass a law, and the president passes it into a law. So instead of the treaty process of Article 6 of the Constitution, Congress has turned this, with that 1871 Act, into an issue for both the Senate and the House and the president and relations with tribes. Tribes are dealing with the United States all the time about water issues, land issues, resources, you name it. So this political diplomatic relationship continues to this day for all 574 federally recognized tribes, whether they have a treaty or not. Next slide, please. I think Cree mentioned this already. Here's an important Supreme Court case that I'll just barely mention again later, 1979. This is about the salmon fishing rights, treaty rights in the Pacific Northwest. And the Supreme Court said that treaties are contracts between nations, and Indian treaties are the same things. So this is where we talk about this being like a contract. And normally one side can't just break it. And always, if one side does break a treaty, litigation can follow for money damages. And that's my point from the earlier slide, that if the United States abrogates Indian treaty rights, there should absolutely be a lawsuit for a taking of property under the Fifth Amendment. Next slide, please. I'll mention this case twice. The fishing rights, the treaty fishing rights from the Pacific Northwest have been litigated in the U.S. Supreme Court 7 times. And the reason I mention that, Supreme Court doesn't like to hear the same case over and over. 7 times since 1905 in the Winans case, the Supreme Court has had to look at the treaties that the tribes in the Pacific Northwest signed with the U.S. and decide what their salmon fishing and whaling fishing rights for the Macaw Nation. But a very important principle is stated in this Winans case, 1905, and it's from the Pacific Northwest, Yakima fishermen in the Columbia River. The Supreme Court, I think I have the language maybe on the next slide, but I can quote you this. The treaty is not a grant, this is a quote, a treaty is not a grant or right to the Indians, but a grant of rights from them, a reservation of those rights not granted. I hammer this quote into my Indian law class every year. Tribes were negotiating with the United States. Well, there's the treaty. There it is. Did I get the quote right? The treaty was not a grant. Oh, I put the dash in the wrong spot. There's a very important principle of law, folks. The United States was coming hat in hand to ask tribes, we'd like to buy land from you. Or maybe even we'd like you to move west of the Mississippi. Or we'd like peace and to stop fighting. Cree mentioned several of these points. The United States is the one that almost always approached tribes. Tribes didn't go to Washington, D.C. begging for a treaty very often. It was the exact opposite. The United States came out to tribal leaders, came out to where tribes lived, and tried to make a treaty, tried to make a contract. So the United States Supreme Court in the Winans case made this important point. In fact, folks, why do we call our Indian homelands, why do we call them reservations? Have you ever thought of that? And in Canada, for the First Nations, they're called reserves. What's the identical same idea? This area of land where Tribe X lives today is what it reserved from its much larger territory that it perhaps agreed to sell to the United States in a treaty. Many of you know the history of various tribes and how these negotiations and how manifest destiny took place, etc. But the idea that the tribes, the rights they still have, the U.S. didn't give it to them. These were rights these tribal nations, these tribal peoples possessed, and they chose to keep, not to sell to the United States. And that's the point the Winans decision made. And remember, that's a treaty case, salmon fishing treaty rights out of the Pacific Northwest. Next point, please. Now, as a contract, the Supreme is interpreted. The Supreme Court has decided over these past 100 plus years how to read and interpret Indian treaties. Now, you well know that most Native peoples didn't speak English. They didn't read and write English. And when these treaty sessions that went on for 2 and 3 days, while the tribal leaders were talking to whoever the federal officials were, sometimes they were military men, sometimes they were just political employees. This being discussed in English. And the language is being translated to the tribes. This document's finally showed to the Native people. Here, put your thumbprint on this. Some Indian people put an X mark. Some Indian people, there are treaties that the Indian person used their personal totem symbol. I guess it's the correct word to call it a totem, but it's a symbol that person used in essence as their signature. But they couldn't read this document. So the Supreme Court has long had 3 main rules for interpreting Indian treaties. If there is any ambiguity in this written document, it gets interpreted against the United States. Now, you might think, wow, that's pretty fair. But that's just the principle of contract law, folks. I don't teach contracts, but when you come to law school and study contracts, you'll hear one of the principal factors. Whoever wrote the contract, if there's something in it that is vague or ambiguous, you interpret that against the person that wrote the contract. Now, that makes perfect sense because that's the person who put the ambiguity into the language. So the Supreme Court has taken just this basic principle of contract law and has applied it to the contracts that the United States signed with Indian nations called treaties. So if there's anything ambiguous in a treaty, that has to be construed against the United States and in favor of the tribal peoples and the signatories of those treaties. Next, and while I just said that, I want to make a point. A treaty is only between that nation and the United States. So here I'm in Portland, Oregon right now. The treaties that divided the lands and divided the rights for salmon here only apply to the tribes that signed those treaties. I have no particular rights to go salmon fishing in the Columbia River because I'm a citizen of the Eastern Shawnee Tribe. I have to buy an Oregon license to fish. I have to follow the Oregon rules. But the people of those tribes, the signatory tribes of those treaties, that's who possesses those treaty rights. And they fish in the Columbia River without a license from the United States, a license from Oregon or Washington. And they are exercising their treaty rights. I, an Indian from another tribe, do not exercise that signatory tribe's rights. Next point, please. Also, understanding how these treaties were negotiated. We try to go back and use history. We try to use the testimony of elders who tell a court what their grandfather told them the treaty meant, their grandmother, what they say about what happened at Walla Walla, Washington on June 8th, 1855, when the Yakima and the Nez Perce and other tribes signed treaties with the U.S. Literally, the court tries to divine what the native peoples at that treaty session would have understood they were promised the treaty said. When Governor Isaac I. Stevens, for example, who was the governor of the Washington Territory in 1855, when he's over at Walla Walla, Washington, and holds up the paper, the treaty, and says, "This paper guarantees you your fish." That's a quote from the Walla Walla Treaty Negotiation, June the 8th, I believe, or 9th, 1855. The United States Supreme Court and the federal courts take that promise very important. They give great importance to a promise like that, because what the Indian peoples were told, what these chiefs and leaders were told, is what they agreed to do. And so what did Governor Isaac I. Stevens tell them? What does a military leader tell them, etc.? So that also sounds fair. Next point, please, Cree. Never interpret a treaty to prejudice the tribe and the Indian peoples. Always interpret it in their favor. Here's a point I started to make earlier. I bet every one of you, when you were in grade school, second grade, third grade, the teacher played this game called telegraph or telephone or something. And the teacher would tell just a few little sentences to one student, and that student would whisper it to the next, and then next and next. I bet you did it. I did it in school. And by the time that story goes through 3 or 4 people, it's not even the same story. What's the point? I don't know. Hearsay evidence isn't very good. But how does that apply to treaty making? The treaties that were negotiated here in the Pacific Northwest, folks, that I've written, I'll give you a citation to the article later if you want to look it up. But while the colonel from the United States stood there and talked in English, he had a translator who could speak Chinook jargon. If you've never heard of Chinook jargon, it's a trade language of about 300 to 500 French, Spanish, and English words. And so the colonel speaking in English, I guess a native person or maybe some local person who thinks they can speak Chinook is now translating English to Chinook and then now translating it to some native who speaks Chinook who's now translating it into the tribal language. Now you think of the telegraph story that you did when you were in grade school and everyone spoke English. So here's a very valid reason, a very fair reason to not interpret treaties against Indian peoples, because what words were being used? Did they have lawyers with them to divine what each legal term in the contract meant? Well, that's just ludicrous, of course. So that's why the federal courts and the United States Supreme Court have long developed these ideas. I think there's one more bullet point here, Reedy. Now, before we all get all, a tear runs down our cheek and we get all mushy at how wonderful the Supreme Court has been in interpreting treaties, this is really just contractual law principles. I've already mentioned to you how ambiguities are construed against the person that wrote the contract. That is law, has been law for hundreds of years. And I added these words, a meeting of the minds. My bullet point, let's see, 1, 2, 3, my bullet point 3 and 4 there are both pretty much just trying to find out what did the tribal leaders agree to and what did the United States representative agree to. And in contract law, we call that a meeting of the minds. Let me give you an example. Let's say I own 2 cars and you come to my house to buy my car and I have an old beater Ford Pinto out here and I sell it to you for $200. And later you claim, oh no, I bought that Mercedes of yours, your brand new Mercedes. Well, that's a contract that would not be enforceable because you and me did not have a meeting of the minds on what car I was selling you for $200. And so this is a principle that literally applies to courts trying to interpret what a treaty means. Did the United States understand it was buying this hunk of land? And did the tribal peoples agree it was selling that hunk of land and not something else? So while these principles, we are happy that we have these interpretive tools and that the United States Supreme Court has been fairly favorable to reading treaties in favor of tribal peoples. I don't want anyone, to get all mushy and the tear runs down our cheek that the United States is oh so wonderful. I mean, this is not much more than just international law principles, contract principles, and the same international law treaty principles that have always been applied. Next point, please. Oh, here we get to the important. So I'm moving on now from sort of the basic principles of understanding what treaties are. We've talked a bit about how they get interpreted. We probably all know a little bit about how they were negotiated and how unfair that situation often was. I haven't even said this. In many in many treaty situations, alcohol was handed out. The United States picked the chiefs they would negotiate with. The treaties here in the Pacific Northwest, I've mentioned his name, Governor Isaac I. Stevens. He was famous for picking which people he'd call a chief and who he would let speak for the Yakima, the Nez Perce, the Chehalis, all the other tribes in the Puget Sound area. So again, the Supreme Court recognizes that this situation was fraught with problems and both bribery and alcohol and anything you can think of. But so now we're moving on from that point, how these treaties were negotiated. And I'm going to talk about how some treaties have been used. Cree and the National Governance Center Native Governance Center asked me to talk about some of the great victories or how they have been used. And we have probably the prime example of the use of treaty rights is going on right now in the state of Oklahoma. This is the cover of a book I wrote with a professor from Mississippi, Robbie Etheridge. Yeah, I know it's fuzzy. That's the best I could get it until I enlarged it. So we called this book A Promise Kept. And it's about the Muskogee Creek Nation in Oklahoma and a 2020 U.S. Supreme Court case called McGirt v. Oklahoma. So I'm going to talk about that for a little bit, and then I'm going to mention, I think, three other examples of treaty rights in just the 2020s at work and the value that it brings to those tribal nations in both cultural preservation, economic development, religious rights, you name it, helping the tribe stay as a cohesive unit, etc., the value of treaty rights. Next slide, please. So I'm going to talk about this McGirt case for a bit and only have a few seconds to talk about what this means in Oklahoma right now. But this is playing out in Oklahoma right now. The governor of Oklahoma and many people in Oklahoma are in an uproar over 4 years later now of the case McGirt v. Oklahoma. So the Creek Nation is one of the tribes that was from the American Southeast, I believe Alabama and Mississippi area maybe. And the United States wanted them to move west of the Mississippi. So in 1832, the Creek Nation signed a treaty with the United States. You can see some of the language quoted there. Yes, we will sell you our lands east of the Mississippi for lands west of the Mississippi. But it will be the home for our whole nation. You, the United States, solemnly guarantee it, and we will govern ourselves. So these are promises that should be kept, right? These are legal provisions in this contract, this treaty. We will sell you our lands in the east. We will move west under these conditions. Next point, please. The tribe signed another treaty. So once they got in the area, what's now Oklahoma, boundaries had to be set out. They signed a treaty, I believe, in 1836. Now they signed this 1856 treaty. No part of Creek lands will ever be inside a federal territory or a state. So Cree mentioned earlier how the United States, we all know the statement, the broken treaties. Well, this is absolutely a promise that the United States made to quite a few tribes, especially the tribes that moved to what's now Oklahoma, what was called the Indian Territory. The tribes were smart enough to know we don't want to be inside a state again. In fact, we don't even like being inside United States. So look at that promise. You will never be within a territory or state again. So that's absolutely, those provisions in those treaties have been broken completely. But what I want to emphasize again, the Creek leaders said we want full self-government. we will have full jurisdiction over our people and our property. And the United States agreed to that, a solemn promise, Article 6 of the Constitution. It's the supreme law of the land. Well, then the Civil War happens, folks. I'm going to show you a map in a moment, and we're going to get to the next treaty that really the McGirt case was about. And some tribes in what's now Oklahoma supported the South. In fact, many tribes were split. Part of the tribe supported the North, part of the tribe supported the South. But the United States used the Civil War as a reason to punish all the tribes in what's now Oklahoma. So next point, please. My own tribe was forced to sign an 1867 treaty, also blaming us for supporting the South. Really not even true, but that the U.S. used it as a very good excuse. But the Creek Nation in 1866, along with the other, what are called the civilized tribes, they prefer to be called the 5 tribes now, ceded half of the lands they had in what's now Oklahoma under their 1836 and their 1856 treaties. Now, you'll look what it says. It was supposed to be for other civilized Indians. But the eastern half of the Creek lands in what's now Oklahoma were forever set apart as a home for the Creek Nation. And look at the quote on the reduced Creek Reservation. That's one of the earlier uses of the word reservation, and certainly the first in a Creek treaty. The word was kind of relatively new. The federal government started a new federal Indian policy called the Reservation Era in 1850. So this was a new idea of moving tribes to smaller and smaller areas of land, hopefully far away from Americans and safe, and where tribal peoples could live. But the use of that word is extremely important in the McGirt treaty case. Remember, this is a treaty. And so now how do you enforce that right? So I now have 2 slides. Next slide, please. Take a look at that, folks. That's the boundaries of Oklahoma today. There would be no Oklahoma if those 5 tribes still had all the land that their treaties from the 1830s and 50s, et cetera, had guaranteed to them. But those 5 big tribes ceded all that dark gray area after the Civil War at the insistence, the threat of the United States. The next map is important because it shows my tribe. Look at the very top right corner there, and then that long arrow, the Eastern Shawnee Tribe. So that's where, there's 9 tribes up in the northeast corner of Oklahoma there. And there's where my mom was born, and that's where my tribe is today. And because of the McGirt decision, folks, my tribe's reservation has been re-recognized. I'm getting ahead of myself. But because of McGirt, next slide, please, Cree. I'll just get to that point since I'm talking about it. This opinion was written by Justice Gorsuch. Now, Justice Gorsuch was President Trump's first appointee. He's a very conservative justice, but he is dedicated to enforcing Indian treaties. Now, one could argue that that's based on his conservative view that we look at the history and we judge laws and statutes and constitutional provisions from the date they were enacted. So he writes the majority opinion in the McGirt case, which is only 5-4. So without Gorsuch's vote, the 4 conservatives, the Creek Nation and Mr. McGirt, would have lost this case. But Gorsuch writes the opinion. The Creek Nation reservation has never been changed by Congress. Now, remember what I say about 5-6 slides ago. Congress has the power to unilaterally abrogate a treaty. It unilaterally has the power to make reservations smaller. That's what we mean by diminished, or to do away with them completely. And that's what we mean by disestablished. But Gorsuch searched the history books, searched the law books, and found that Congress had never done a thing to the borders of the Creek Reservation. Next point, please. I guess I repeat it. Next point, please. And the 1866 treaty has never been abrogated. Yes, the Creek sold half their lands, which we looked at that one map, how much of Oklahoma was in the dark gray, but the white parts of that map are still Indian reservations. And Gorsuch starts the opinion with this quote, folks. I assume you all know what the Trail of Tears is, the removal of the tribes primarily from the American Southeast. My tribe was removed in 1832 from South Central Ohio. So we had our own Trail of Tears. But normally, when the phrase Trail of Tears is used, you're talking about the removal of the 5 tribes from the American Southeast. You know the tribe had won the case when you read that very first sentence. In fact, my wife woke me up the morning of July the 9th, 2020, and she goes, I think the tribe won that case. And I couldn't believe it. My wife's a lawyer, super smart. I knew she knew who'd won the case. I jumped up right away, got on Westlaw and read the opinion. And so I've been working on McGirt, analyzing it, writing about it, and now the book from 2023. And that's where we took our title, A Promise Kept. You read that opening line, and you know the tribe won. So Gorsuch and the other 4 justices looked back at history and law. They looked at that treaty from 1866. A reservation was created. The tribe will govern itself. The borders are where the tribe governs and is the tribe's lands. And it's never been changed. There was a promise. Next point, please. So this is a federal criminal statute, 18 U.S.C. 1151A, and it's the definition of Indian country. So this is a term of art when we talk about a legal term of art when we talk about Indian country. This is where the tribe primarily exercises its sovereignty, and certainly over its own people, and certainly over other Indians who live there. So the definition of Indian country is crucial. It's also where the United States has all sorts of powers. And if you know your federal code, 18 USC stands for United States Code, USC. And Section 18 of the United States laws is the criminal code. So 18 USC 1151 is literally defining what is Indian country to know where the federal government has criminal jurisdiction over Indian crimes or crimes against Indians. So it's extremely important that this entire area is now Indian country. Cree, please go back to that gray map or the first map, will you? Okay, right. Go forward 1 map, please. So take a look at the size of the Muskogee Creek Reservation, folks, in modern day Oklahoma. My co-author and I calculated that the Muskogee Creek probably owned land, and everyone assumed its only jurisdiction was over about 135,000 acres on July the 8th, 2020. When I woke up on July the 9th, 2020, and the McGirt decision had come out, take a look at the boundaries of the Muskogee Creek Reservation. It's all Indian country. 3.25 million acres of land. Not 135,000 acres of land that the tribe owned the title to with the United States, and that perhaps individual Muskogee Creek people owned the title to with the United States in trust, if you know what trust ownership means. So on June the 8th, 2020, the extent of Muskogee Creek Indian country was deemed to be that 135,000 acres. On the morning of July the 9th, the Muskogee Creek Indian country returned to, was re-recognized as its 1866 treaty boundaries. Now, I will say this in a moment, but while we're looking at the map, Oklahoma state courts have since re-recognized the reservations for at least 9 other tribes in Oklahoma. So look at Chickasaw on this map. Look at Choctaw. They both look bigger to me than Muskogee Creek. Look at Cherokee and Seminole. And then many of the small tribes, where mine is one of them, Oklahoma state courts have now, using the analysis from Gorsuch and from the McGirt decision, have held that this is all Indian country. Now, this is shocking. I understand why the governor of Oklahoma is shocked. What a sea change, folks. Now, I'm a tribal advocate. There's my tribe. My tribe has our reservation back. This is a fabulous victory. But everyone, I think, has to recognize that this is shocking. And so when we're talking about treaty rights, and that's the title of this topic, of this talk, I think I could quit now. What's the old, clap my hands and walk away? I don't know who does that, magicians or somebody. But wow. And Oklahoma is struggling to this day to deal with this. The tribal governments are struggling too to deal with this vast expansion of their jurisdiction, their sovereignty, their governmental responsibilities. All of these tribes have had to hire more prosecutors, more cops, more judges. Can you imagine just the criminal and civil caseload that is increased in the court system? So this is an enormous change that could easily take decades to fully absorb. So I encourage you to buy my book if you want to read more about McGirt and the changes that are going on. Okay, please go forward, Cree. Next slide, too, please. I may be mentioning next point, please. Okay, 46% of the state of Oklahoma is now inside an Indian reservation. No state in the country. I teach in Arizona now, right? And for the past 11 years, I've lived in Arizona. That was the state that had the most Indian country inside its borders. 27% of Arizona is Indian country because of the enormous Navajo Nation reservation, San Carlos Apache, Tono Otham, and several other tribes. But Oklahoma is now 46%. And in fact, when you count the tribes in the west of Oklahoma that have not yet been impacted by McGirt, 49% of the state of Oklahoma is Indian country. And 1.8 million Oklahomans now find out they live on an Indian reservation. Wow. That's all I can say. Wow. Next slide, please. I think I move on to topics. Oh, okay. I mentioned there's my own slide again, my own tribe. So we have a tiny little reservation, but I've been back there many times, and you drive in, there's a sign that says, "Welcome to the Eastern Shawnee Tribe Reservation." That kind of moving. Okay, here's some other cases that, yes, Gorsuch was involved in, and that the court in just the I said 2020, so this is 2019, two cases from 2019. This is a Yakima tribe case, and if you've read it already, it was about a fuel importer. They would bring gasoline from Oregon, and I guess heating oil and diesel, whatever, and drive up to the Yakima Reservation in Washington. The business was incorporated under the Yakima Nation law, and the Yakima Nation had literally named this company, Cougar Den Inc., the agent to obtain fuel for the tribe. The state of Washington, looking for money, said, well, we want to tax you like we tax all people who transport fuel in Washington. And they tried to collect $3.6 million from the Cougar Den Inc., a privately owned company by a Yakima person. But you already see the facts. Next point, please. Agree? But the tribe has, I've mentioned this 1855 treaty already. And what I do not know, folks, is if the other tribes in the state of Washington have this identical provision in their treaties. So I do not know the answer to that question. If they do, this Cougar Den case is of great interest and importance to them. But the United States Supreme Court, and again, it's a 5-4 decision. Justice Gorsuch did not write the opinion, but he provides the fifth vote. Without his vote, the Yakima Nation and Cougar Den would have lost this case. But the tribe's right under the 1855 treaty, its 1855 treaty. 5-minute warning. I'm going to have to move faster. Okay, next bullet point, please. I have 5 minutes, I'm told. So I guess I don't have the quote of the language, but the tribe had reserved in its negotiations, we want to be able to travel on the state highways to engage in trade and to bring goods to our reservation, etc. And the Supreme Court upheld that language and enforced it against the state, and the state was not allowed to collect those taxes. Next point, please. This is a hunting case of a Crow citizen in 2019. The Supreme Court decides he was convicted for hunting in Wyoming in the Bighorn National Forest, but it was part of the territory of the Crow people where they had hunted and had treaty rights. Next point, please. His conviction was vacated because the treaty had this provision: the tribal peoples could continue to hunt on the unoccupied lands of the United States. Next two bullet points, please. So even though this area had now become Wyoming, that didn't change the tribe's treaty right. The treaty did not expire just because Wyoming had now become a state. And that the fact that the feds made the Bighorn National Forest into a national forest did not somehow mean the lands were now occupied, so that the tribe's right to hunt on the unoccupied lands had now expired. Next point, please. We can end this pretty quickly, I think. Mining and logging in the Bighorn National Forest did not occupy the lands. And next point, please, Creed. I think I already mentioned this. Justice Gorsuch, again, he did not write this Herrera opinion, but he votes with the majority, and it's a 5-4 decision. So I think the last slide, next point, please, Creed. I cover these cases, I don't really cover them at all, but the Pacific Northwest treaty fishing cases I've already mentioned have been litigated 7 times in the United States Supreme Court. Hit the next bullet points, please. The tribes have won almost every aspect in all 7 of these cases. These were major triumphs of treaty rights. Oregon and Washington were arresting Indian peoples. Indian peoples were shot at while they were fishing. Marlon Brando was on the Columbia River with some Indian people protesting for Indian rights. Next point, please, Creed. This went on from the 40s. And well, obviously from 1905. What was finally decided in these cases? Treaty fishermen and women, got 50% of the Columbia River harvest of salmon, even though they were just 1.5% to 2% of the population. Now, some people might be kind of shocked at that for a moment, and maybe you've heard that treaty rights are called special rights or unequal rights. No, that is false. As we've been talking, these are contracts, these are treaties that the tribes signed with the United States. And so the fact that these treaty fisher people got 50% of the catch is because of a contract that their nation signed in 1855 with the United States. And the fact that the catch is divided in different ways is just something that the United States agreed to. And it's constitutional law under the Article 6 of the Constitution. So it's not a special right, it's a treaty right for those tribes, those tribal fisher peoples. Next point, please. I think I'm almost done. Now, here's an article I wrote long ago, 1991, when the salmon were being listed to the Endangered Species Act. I wrote about what will happen to treaty rights. You can get that article for free at that point, at that link. Next slide, I think free is just all 3 of my articles. Hit all 3, please. There I wrote a chapter on my own tribe's treaties. I wrote a pretty recent, 20 years ago, 2001, about when the Macaw were exercising their treaty rights to go whaling. And they are finally about to be able to resume whaling again. The tribes wait, they fight, they enforce their rights. The tribes think 7 generations down the road. And these are fabulous victories that we can all be proud of. We can all see the Constitution at work, and we can see at least some fairness to Native peoples through treaty rights. So I hope this has given you some enlightenment on what treaties are, how Indian treaties came about, how they're interpreted, and then we've looked at 3 or 4 examples of some great victories from treaty rights. So thank you very much. Thank you, Native Governance Center. Thank you, Cree.
Chimiwech, thank you so much, Professor Bob. I think I was chatting with one of my coworkers and we were learning so much even as you were presenting. And for everyone who joined us today, please know that all of the links that were shared out in the chat will be shared with you later on today via email. So look out for that for some additional resources and opportunities to learn. But we just want to say thank you again for attending this session with us. We so appreciate Professor Bob Miller for joining us today and sharing his knowledge on this topic, and really just all of the good energy and information. We want to say thank you to everyone who attended with us virtually today. Our apologies if you didn't get your question responded to, but look out for a guide that we will be publishing in the next weeks on this topic. And we're also going to offer part 2 of this series coming up next week at this same time. So we just again want to thank everyone for joining today. We would like to hear from you, so we'll email out a survey to our Zoom attendees, and we will be posting this recording as well. So if you want to go back and rewatch or share it for others learning, that will be available soon. And just stay tuned for future virtual events from Native Governance Center. Next week, as I mentioned, we're going to have part 2 of this series. And then in September, we're going to have one around dispelling common myths about Indian country. We're so excited to share details. And again, just want to thank Professor Robert Miller for his time today and all of the really beautiful information that you shared.
Thank
Many
you.
blessings, and thank you all for joining, and hope you have a beautiful day. Giga Wabamin, we'll see you again soon. All right. And thank you so much. I'm going to stop the recording and close out the event today.